doing? Okay.
Morning.
Oh, good morning. How you doing?
How are you?
I could be better, but I'm hanging in there.
Well, my name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning John Lamotte, 322-752. Today is Tuesday, January 7th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office at Corrigan Correctional Institution. Please state your full name and DOC MA number for the record.
John Lamotte, 322-752.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony in today's hearing will be taken under oath. Mr. Lamotte, please raise your right hand. You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, ma'am.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Not really. I pretty much understand what you're saying. So,
Okay, thank you.
okay.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, drug testing. On September 14th, 2024, you were instructed at the halfway house staff to submit a urinalysis and a breathalyzer which you refused. On September 24th, you admitted to your parole officer that you drink alcohol and you were instructed to submit a urinalysis and a breathalyzer which you refused. Charge 2, obedience to the law. On September 15th, 2024, you made an unwelcome sexual advances towards a female halfway house staff member by making comments regarding her appearance, including calling her beautiful and stating that she was giving you a hard-on. You engaged in conduct with the purpose of affect or substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. On September 15th, 2024, you were arrested and charged by Connecticut State Police, Troop E, Montville, for sexual harassment. On September 14th, 2024, you made the threatening comment to your roommate at the halfway house, "If you weren't my friend, I would have killed you already." On September 15th, 2024, you made a threatening comment to your roommate I could break your face, but that would be too easy. Halfway House reported that on September 15th, 2024. You also stated to them that the Halfway House needed to change your roommate or you were going to end up killing him, your roommate. You engage in conduct which, by physical threat, such person you intentionally placed or attempted to place another person in fear or serious physical injury. On September 15th, 2024, you were arrested and charged by Connecticut State Police Troop E Montville for threatening second degree. Charge 3, no consumption of alcoholic beverages. On or around September 14th, 2024, you consumed alcohol. On or around September 15th, 2024, you consumed alcohol. Charge 4, halfway house placement. On September 14th, 2024, at approximately 11:11 p.m., you voluntarily exited your only parole approved residence, halfway house, without permission from halfway house staff or parole. Attempts to locate you were unsuccessful until you contacted your parole officer via phone on September 15th at approximately 1 p.m., at which time you were instructed to return immediately to the halfway house. You returned to the halfway house at approximately 2:30 p.m. on September 15th, 2024, making you unaccountable in the community for approximately 15 and a half hours. Your actions are in violation of your signed halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. The state has filed the following exhibits: remand, or Exhibit A, remand to actual custody order; Exhibit B, signed PCF conditions; Exhibit C, notice of parole violation and parolee rights; Exhibit D, parole violation report; Exhibit E, halfway house agreement; Exhibit F, halfway house incident report; Exhibit G, Connecticut State Police report ending in 866; Exhibit H, Connecticut Judicial website pending case detail. Excuse me. Exhibit I, BOPP revocation hearing summary dated 7/31/24. The state found an addendum to Exhibit D, which states on December 2nd, 2024, Mr. Lamotte was sentenced to 90 days jail for threatening second physical threat under docket ending in 285. The charge harassment second was nollied. It's important to note the addendum also states Mr. Lamotte was never charged with sexual harassment. Counsel, did you receive the notice of parole violation report and the other documents that were marked for identification purposes?
Yes, I have.
Okay. Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes, that's the charge 1. On 9/15, my client actually admitted that he had consumed alcohol. He was never offered an opportunity to drug test, so he disagrees with that, that occurred on 9/15. I don't believe the preponderance of the evidence is met regarding the harassment charge whatsoever, and certainly regarding sexual harassment, as those charges were never brought. No comment as to the threatening conviction. However, he had been gone for a period of time because Vic, the staff member, actually said, you can't stay here unless you give a test. So he left the halfway house. He had permission. When he returned, his roommate was in his property going through his things, and that's why there was an altercation between those individuals. There was no intent to threaten him. He was just telling this individual, don't go through my property. And so there was a verbal, and he got a ticket for that. What I can say is, I don't believe the preponderance is met for the second part of charge 1, the first part of charge 2. Those are my comments as to the preponderance standard.
Thank you.
Excuse me, ma'am. The reason I didn't sign all that paperwork and I refused to sign is because a lot of that stuff wasn't accurate at all. Half of it wasn't true. And that's why it got, this far and whatever. The truth was stretched quite a bit.
Okay.
Thank you.
Yeah.
Anything further?
Not
Excuse
as
me?
to the preponderance standard.
And nothing further, Mr. Lamotte, before I announce my findings regarding the charges?
I'm sorry.
Regarding charge 1, drug testing, I make a finding based on state's exhibits B, D, and F. On charge 2, obedience to law, I make a no finding on part 1 as the state improperly charged Mr. Lamotte. I make a finding on part 2 based on Mr. Lamotte's conviction as well as state's exhibits B, D, F, G, and H. On charge 3, no consumption of alcoholic beverages, I make a finding based on state's exhibits B, D, F, and G. On charge 4, halfway house placement, I make a finding based on state's exhibits B, D, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes. Although my client was at the halfway house for a short period of time, he had been cooking roughly 25 meals a day voluntarily because there was an issue in the kitchen with the cooking staff. And so he stepped up and was cooking for the entire halfway house. He's a single 59-year-old male. His primary source of support is his 84-year-old mother, and he is her caretaker. He has 3 sons and 4 grandchildren, all of whom reside in Rhode Island. He completed the 8th grade and then admirably later obtained his GED. He was employed full-time as a construction concrete worker with Ricky Entwistle in Wesley, Rhode Island for some time. He has no behavioral health treatment history. He had applied for a job while he's been incarcerated, and upon reinstatement, he'd like to be placed in a halfway house, preferably the Fellowship House or the Connections Reach Bed in or near Norwich, Connecticut. I don't believe any of these violations are significantly serious enough to further incarcerate my client. He's already been held since September 15th. His parole officer recommended mental health and substance abuse evaluation. That's certainly not going to happen while incarcerated. And 6 months of jail. I think the 6 months is excessive. He only received 90 days for the threat. We explained the fact that someone was going through his property when this confrontation occurred. It takes 2 to tango. My client believes, and we believe, that it was the other party that's at fault. He was merely defending himself. All he has in a halfway house is his private space, which is always going to be intruded. And his privacy rights to his property are very important to him. We don't think these violations are so serious to warrant further incarceration. There's no history of violence here. Thank you for your time and consideration.
Thank you. I'm going to take a moment before I make my recommendation. Okay, Mr. Lamotte, because this is your second violation, you were in the community for approximately 5 days and was arrested within that time frame. And as a result of the arrest, you did receive a new conviction. I recommend revoke and re-parole on March 17th, 2025, which is an approximate 6-month sanction with the following conditions: no consumption of alcohol, domestic violence, a general no contact with RB and Stop and Shop located at 220 Route 12 in Groton, halfway house placement and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 16th, 2025. So on that day, the board is going to take a look at your case, and they can either lessen my recommended sanction, keep my recommended sanction, or they can exceed my recommended sanction, being that you're on special parole until 2031. And in the event that they do want to exceed my recommendation, another hearing would take place, and you would receive reasons documenting why they would want to exceed my recommendation of the 6-month sanction. Okay? So again, your board review is scheduled on January 16th, 2025, and at which time the board will make their final decision. Okay?
Okay, yeah, thanks.
So, sir, give me a call the next day on the 17th, and I'll let you know what the board decided. Hopefully you'll be going home on the 25th of March or sooner, okay?
Wasn't it the 15th?
It's a six. I recommend this.
I think it was the 15th.
March
The 17th, March 17th. The start 17th.
March 17th, my bad. March 17th, St. Patrick's Day. Okay, sir?
All right. Thank you, Robert.
Call me. You're welcome. Call me if you have any questions, sir, okay?
All right. Yep. Thank you,
All right.
ma'am.
Thank you.
Have a
All
nice
right.
day.
You too.